Our last speaker would be Nick. Nick is a student of Professor Chen, and among all of us, he is the only one being mentioned in the introductory page of this book. Nick, please come to the podium.
Good afternoon, everyone. Can you hear me?
Yeah.
Yes.
Wonderful. I have to say it was a really great honor to be able to assist Professor Chen with this book and with 2 other books that he's published. And it's also a great honor to be able to share this forum with your very distinguished professors. It's a treat for me. I'm just a lawyer. I was one of Professor Chen's students in New York, and now I'm a lawyer in Hong Kong, where I advise companies on compliance with economic sanctions. And that might not be very interesting to most of you. It's very interesting to me, but I thought I could relate it back to the book and to some of the things that we talked about today. And to do that in 2 ways. First of all, I wanted to say that I use the approach described in this book every single day in my work as a lawyer. And that's because the area of law that I work in, economic sanctions, has a lot to do with foreign policy and a lot to do with international relations. And as Professor Chen said, that topic and law are very closely related to one another. And when I advise my clients, I need to think about perspectives and trends. I need to make recommendations, and it's not enough just to look at a regulation. You have to be able to interpret all of the facts and all of the signs and conditions in order to come to the right answer. And I think that's something that's illustrated in this book very, very well, but in the area of human rights. Now, the second way that it relates to my work that I wanted to share, and this is mentioned in the introduction in section 7, is that economic sanctions are one of the ways that human rights are enforced and applied in the international community. This is done through the United Nations Security Council, for example. It's also done through national governments, the United States, the European Union, even China and Taiwan. Now, what's most interesting, I think, recently, and what I wanted to draw attention to, is the evolution of the use of sanctions against individuals who are accused of serious violations of human rights. And in particular, the governments of the United States and Canada, the United Kingdom, and soon the European Union have adopted laws which are known as the Magnitsky Sanctions Act. And they're named after a Russian lawyer, Sergei Magnitsky, who was investigating corruption in Russia. He was taken into custody, and over the course of several months he was abused in custody and ultimately died. And these acts, which are being adopted around the world, are meant to provide a standing legal authorization to governments to adopt economic sanctions against foreign officials who have been involved in serious human rights abuses. The Magnitsky sanctions in the United States have been used over the past year against officials in numerous countries, from Russia to China, Pakistan, Myanmar, Nicaragua, those are just a few of them. And there's even been some talk of using them to address the situation in the Xinjiang Uyghur Autonomous Region in China due to human rights violations there. So they're very, very powerful tools. Now, what is also interesting about the Magnitsky Acts, and another way that they relate to the topics that were discussed in the introduction, is that in a way they're competing with some other forums that exist, including domestic courts, ad hoc tribunals, and the International Criminal Court, because they offer an alternative way of seeking justice against individuals who've been accused of human rights violations. And I think that's interesting for really a couple of reasons. Number one, this is taking place entirely outside of the United Nations framework. This is being enacted under national laws. And so I think we have to ask important questions about the fragmenting of international authority and international cooperation. But also, there's been no talk of referring any of these cases to the International Criminal Court. And so we have to ask questions about due process and whether or not the individuals who are accused are being treated within an appropriate forum that takes into considerations the need for procedure and so on. An important case where this has been used that you may have read about is with the case of Jamal Khashoggi, who was a journalist who was killed in the consulate of the Saudi Arabian government in Istanbul. And the Magnitsky Act was used in the United States to target 17 individuals. Canada used their law to target 17 individuals. And the European Union used a similar but very different mechanism to target the same individuals. But again, this was outside of the United Nations framework, and it is not taking place within the ICC. And so I think, in conclusion, there's so much that can be said, but in conclusion, I think it's important and welcome that we have these developments in an area of law that I'm lucky to practice in. But at the same time, we need to remember the importance of these international bodies that have developed over time, and the importance of expressing the desires of the international community for justice and human rights through those authoritative institutions. And those are all things that are discussed in the introduction to the book. And so I hope I've been able, in a few minutes, to illustrate how I've been able to apply that framework to my own work. And so once again, thank you, Professor, congratulations.
Thank you.
This was a wonderful project to work on, and I'm very happy to be here.
And also for the benefits of our audience understanding in Chinese, Nick 是陈老师在纽约法学院的学生，那也是在国际法的研究领域当中做得很棒的律师。他刚刚也用了他现在正在执业的这个有关于这个国际上许多人权或者因为恐怖的这个经济制裁的相关的案例来谈论说，国际法事实上不是只发生在任何一个特定的国际法院或者是国际法的条约或公约。那经济制裁也可能涉及到一个内国的法律，一个内国的法院，那怎么样的在跟许多国际的法院、国际的机制跟国际的规范有许多的互动，那因此延伸出了很多新的讨论。所以很多时候国内的法律也有可能有国际的法律的 implications. Thank you, Nick. And because you are the last commentator, you have the privilege to stay on the comfortable sofa. Now with this incapable moderator,